Cameron Soren here at Soren Law, and today we're going to be talking about the two recent Trump tax return Supreme Court cases. The first one is Trump v. Mazars, and this one begins back in April of 2019, where the House Oversight Committee wanted records as part of an investigation of the adequacy of their current government ethics laws. And so they sought certain records from Mazars, the long-term accounting group for Trump. At the same time, the House Committee on Financial Services and the House Intelligence Committee issued subpoenas to Deutsche Bank and Capital One seeking records related to the president, his family, his companies, as part of an ongoing investigation into possible foreign influence in U.S. elections. Trump then moved to block the subpoenas, but the district courts in Washington, D.C. and New York ultimately declined, as well did the courts of appeals. The cases then became consolidated, and an opinion was issued by the United States Supreme Court on July 9th, 2020. Roberts, writing for a 7-2 majority, ultimately sent the cases back down for another look. Now, right at the outset, Roberts acknowledges that Congress has the power to obtain information so it can legislate effectively. You can't exactly legislate wisely if you don't know what's going on. He continued, however, that this power is not unlimited. Congressional subpoenas are only valid if they have a valid legislative purpose and are not intended for law enforcement efforts. Then Roberts moved to reject the argument made by both Trump and the federal government, which argued essentially that a higher standard required Congress to demonstrate that the information is critical to its purpose. Roberts ultimately said no, that would probably ultimately work to impede Congress in being able to carry out its responsibilities by putting up such a high standard. But then Roberts turned to the arguments by the House, which argued that these records, these requests for records, personal records of the president, should be treated as the same as any other request for documents and should be upheld as long as they have a valid legislative purpose. That approach Roberts was not okay with, as it failed to take into account the significant separation of powers issues that existed here. Essentially, reading between the lines, if Congress is only held to this valid legislative purpose standard, a House controlled by a party different than that of the president could ultimately work a lot of mischief in seeking personal records. In a classic case of an appellate court finding the proposed rules from each litigant more than wanting, Roberts ultimately comes up with a new rule, or rather I should say Roberts in the majority. And ultimately he outlines a 4-factor test for these congressional subpoenas aimed at personal records of a then-sitting president. 1, the court should consider whether the president's papers are really necessary or whether that information could be obtained somewhere else. 2nd, whether the subpoena is sufficiently limited in scope and isn't ultimately trying to capture other information that's beyond its valid legislative purpose. 3, what evidence Congress has to offer establishing that this subpoena advances a valid legislative purpose. And the 4th item is what burdens the subpoena will ultimately impose on the then-sitting president. Now, as the lower courts did not adequately consider these 4 factors, as those 4 factors did not exist until July 9, 2020, the cases will now be remanded to the lower courts for additional proceedings. Justice Clarence Thomas dissented. He would hold that Congress could never issue a legislative subpoena for private, unofficial documents, no matter who they belong to. However, Congress could get at these private documents of the president through impeachment proceedings. Pretty consistent opinion by Thomas and his originalist view of the Constitution. Justice Alito also filed a dissenting opinion, essentially stating that the 4 factors outlined here offered insufficient protection for the president, and because he finds the terms of this test inadequate to protect the president, he respectfully dissents. The second case is Trump v. Vance. And this all results from a subpoena issued by a New York state prosecutor who was looking into investigation by state grand jury into violations of New York state law. They're essentially looking for various different financial records, pretty similar to the Trump v. Mazars case. Now, the president asked the federal court in New York to block the subpoena, arguing that it could not be enforced while he was in office. Both the federal district court and the Court of Appeals rejected that argument. So, then again, we've got Roberts writing for the majority, and joined with Ginsburg, Breyer, Sotomayor, and Kagan. Now, Roberts started off by refuting the suggestion that he could never be the subject of a state criminal subpoena, which seems pretty obvious since one of the earliest cases of this actually happening was treason trial against Aaron Burr, same Aaron Burr who killed Alexander Hamilton, in which Chief Justice John Marshall ruled that Thomas Jefferson would have to comply with the subpoena in terms of turning over certain letters which may have some exculpatory information in them. So that argument didn't hold a lot of weight. Roberts then also went on to dismiss the president's claim that the stigma of the being subpoenaed would undermine his leadership, not only domestically, but also abroad. Well, Roberts took pains to stress that even the president's own attorneys acknowledged that these investigations are allowed under the Constitution, and so the entire argument that the actually be issued a subpoena on top of that would be unlikely to have much of an effect on the president's reputation. Then Trump's lawyers also put forth the argument of absolute immunity. Essentially, the argument goes like this. If he does not have absolute immunity, then state prosecutors all across the country could be issuing subpoenas for private records of the president in order to score various different political points. Roberts was fairly dismissive of that argument as well, ultimately pointing out that there's quite a few protections already built into the state grand jury system, and that grand juries, for example, they can't engage in these fishing expeditions that the Trump lawyers were concerned about. And the Constitution prohibits states and federal prosecutors from interfering with the president's official duties. So, yeah, there could be some multitude of state prosecutors looking to score political points, but they would have to have a sound basis for doing so. Now, the backup argument that was pushed forth by Trump was that any sort of subpoena of this nature would have to meet a higher standard, demonstrating that the evidence is critical to the investigation. Roberts pointed out that this would create a double standard. Essentially, federal prosecutors could seek these materials if they were material and relevant, but it would have to be critical if it was a state prosecutor. That distinction didn't make a lot of sense. And the public interest would be thwarted here, as a lot of the information ultimately sought by these grand juries ultimately reveals a lot of exculpatory information, essentially information that the defendant could use in defending themselves from state prosecution. So it's not simply hampering the investigation of the state, but hampering the investigation or the information that may be presented by the criminal defendant who is the subject of the investigation. Okay. So, given all of those arguments, Roberts, writing for the 5-justice majority, remanded the case back down, stating that Trump would be free to make arguments that any ordinary citizen could make challenging a subpoena, since the courts before had only reached the issue of whether the president, specifically the president, could be immune or somehow block or have the higher standard applied in these cases. Then you have a concurrence in the judgment by Kavanaugh and Gorsuch. Now, they appeared to be pretty close in agreement with Roberts' majority opinion, stating that the president is certainly not immune from state criminal opinions, and the case should go back down to the lower courts. However, they would prefer that state grand jury subpoenas like this one have a higher standard that would require demonstrated specific need for the information the grand jury is seeking here when it comes to a sitting president. Justice Thomas dissented. He agreed the president is not entitled to immunity from issuance of the subpoena, but he argued that the president may be entitled to relief from enforcement of the subpoena. Then Alito also dissented. Essentially, his argument goes that the majority's decision treats the subpoena like an ordinary grand jury subpoena, which it is not. It is a then sitting president, and they deserve greater protection. As the majority's opinion really does not afford that, he respectfully dissents. So that concludes these cases, which essentially mean we're going to have to wait for additional proceedings before we actually find out all this various information regarding Trump's financials / tax returns. As always, I hope you found this enjoyable and informative.